Do you actually know how many separate ways an Australian police officer can lawfully search you without ever setting foot inside a courtroom? Most people guess one, maybe two. There are at least 5, sitting in different pieces of legislation, each with its own trigger, and almost nobody outside policing and criminal law knows all 5 well enough to recognize which one is actually standing in front of them at the roadside. That gap matters more than it sounds like it should, because the single most common of the 5 doesn't come from a statute at all. It comes from you. By the end of this video, you'll know all 5 doorways, which ones need a genuine, specific reason, and which one needs nothing but a signpost you might not have even noticed, and the exact words that make sure the most common one, the one police always try first, never opens on your behalf. Quick word before we get into it. No invented authority on this channel, just plain English Australian law, checked against the actual statutes, every section sitting in the description below. Doorway 1, and by far the most common, consent. If an officer asks whether they can search you, your car, or your bag, and you say yes, that's the entire legal basis needed. No suspicion required, no trigger, no threshold. Once you've said yes, there's nothing left to argue about later. A consensual search is protected from almost every challenge a lawyer could otherwise raise, because the law treats your agreement as the thing that made it lawful in the first place. This applies to your house too. If police ask an occupier for permission to search a home and that occupier agrees, the search can proceed lawfully even if you, specifically, didn't want it to happen, and even if it's your name on the lease. Police are trained to ask for consent first in almost every situation, precisely because it's the cleanest, least challengeable search there is, for them. For you, it's the search that's entirely within your control to prevent, every single time, simply by declining. Doorway 2. The safety and evidence search that follows an arrest. Once you've genuinely been arrested for an offense or an outstanding warrant, police are entitled, under common law principles recognized across the country, to search you and any bag you're carrying, to check for weapons, anything that could be used for self-harm, or evidence connected to what you've been arrested for. This search happens wherever the arrest happens, on the street, in your home, wherever you are at that moment. What it doesn't extend to is your car or your house as a whole. This specific power covers you and what's on your person, not the property around you. That distinction matters, because an officer citing an arrest as the basis for searching your vehicle is reaching past what this particular doorway actually allows. Doorway 3, and this is where most of the drama in this channel's other videos actually lives. Reasonable suspicion searches for drugs or weapons. In Victoria, these sit in the Drugs, Poisons, and Controlled Substances Act and the Control of Weapons Act. In New South Wales, the equivalent power runs through sections 21 and 23 of LEPRA. A police officer can search you or a vehicle without a warrant if they suspect on reasonable grounds that you're carrying something prohibited. This channel has already walked through what reasonable suspicion actually means in an earlier video, anchored in R versus Rondo, the New South Wales case that still defines the standard nationally. Suspicion needs 2 things together. The officer has to genuinely, subjectively hold the suspicion, and the circumstances have to be the kind that would raise the same suspicion in an ordinary, reasonable person standing in the same spot. A smell of cannabis drifting from an open window or a weapon visible in plain sight can meet that bar. A hunch on its own or nervousness with nothing else attached to it generally can't. This channel covered exactly that distinction in the video on the Rondo case, where a denial plus a furtive movement together crossed the line that neither one crossed alone. Doorway 4 is the one almost nobody expects, the designated area search. In certain circumstances, police can declare a specific area, a stretch of street, an entertainment precinct, an area around a major event, a designated search zone, and within that zone, they can search anyone present without needing a warrant and without needing individual suspicion about that specific person. You don't have to have done anything. Being physically inside the boundary at the wrong moment is enough for the power to apply to you. These zones are usually signposted at entry points, but a sign at one entrance doesn't mean every entrance carries one, and it's entirely possible to walk into a designated area without ever seeing the notice. Planned designations are typically published in advance, in Victoria, for example, on the police website or in the government gazette. But unplanned, short-notice designations can and do happen too, which means the only real defense here is knowing this power exists at all. Doorway 5. Warrants. The one most people assume is the only way this ever happens, and in practice the least common of the 5 for an ordinary roadside encounter. Police can apply to a court or in urgent cases to a senior police officer for a warrant authorizing a search of a specific address, vehicle, or defined area for specific items. If you're ever searched under a warrant, ask for a copy of it at the time. You're entitled to see it, and if you're detained while it's executed, that's the moment this channel's advice on every video shifts from handle it calmly at the roadside to get a lawyer involved as soon as you possibly can. There are a handful of narrower powers this video hasn't covered in depth. Searches connected to firearms prohibition orders or powers under family violence legislation, because they apply to a much smaller group of people in much more specific circumstances than the 5 doorways above. If either of those applies to your situation specifically, that's a conversation for a lawyer familiar with your exact circumstances, not a general roadside phrase. A detail worth sitting with on Doorway 1 because it surprises almost everyone the first time they hear it. Consent doesn't have to come from you specifically to open the door to a search that affects you. If you're a passenger and the driver consents to a vehicle search, that consent can validly open the whole car, including your bag, depending on where it's sitting and whether it's reasonably understood to be within the driver's authority to allow access to. If you're staying in someone else's home and that person, as occupier, consents to police searching the property, your own refusal doesn't necessarily override theirs. The practical lesson isn't complicated, even though the legal reasoning behind it is layered. Your own refusal always protects your own body and your own belongings completely, but it doesn't automatically extend to protect a shared space or a bag that isn't clearly and separately yours the moment someone else with authority over that space says yes. On designated area searches specifically, it's worth painting what this actually looks like in practice, because the abstract description undersells how easily it happens to someone with no idea the power even exists. A busy entertainment strip on a Saturday night, a large public event, a precinct that's had a run of reported weapons incidents. These are the kinds of settings where a designated area declaration gets used, sometimes announced well in advance, and sometimes activated with very little public notice. Inside that boundary, the ordinary requirement for individual suspicion simply doesn't apply for the duration of the declaration. You can be searched having done nothing at all, said nothing at all, and given the officer no reason whatsoever beyond your location. The only genuine protection here is awareness, knowing these zones exist, checking whether one's been declared if you're heading somewhere with a history of them, and understanding that a missed sign at one entrance doesn't mean the power doesn't apply to you once you're inside the boundary. On warrants, one more practical layer worth knowing. Not every warrant search waits for a magistrate's signature in the ordinary course of business. In urgent circumstances, some jurisdictions allow a senior police officer, rather than a court, to authorize a search warrant on the spot, precisely because waiting for a judge isn't always practical when evidence could be lost or a genuine safety risk exists. That doesn't make the warrant any less real or any less binding. It just means the word warrant doesn't always guarantee a courtroom was involved in issuing it, and asking to see the actual document remains the right move regardless of which pathway produced it. Now the mistakes, because nearly all of them come back to Doorway 1, the one entirely within your control. Error 1, and it's the single most common mistake this channel sees across every version of this stop. Believing that agreeing to a search makes you look less guilty. It's the opposite of protective. Consenting doesn't just allow that specific search. It removes every argument a lawyer could otherwise make about whether the search should have happened at all. If nothing's found, you've lost nothing you needed. If something is found, you've handed away the one clean legal challenge that existed before you said yes. Error 2. Assuming a refusal has to be argumentative to count. It doesn't, and being combative about it only creates a different problem. The standard is calm and clear, not loud and defensive. "I do not consent to a search of myself or my property," said once evenly, is the entire sentence doing its full legal job. Error 3. Physically resisting once police state they're exercising a genuine search power rather than asking for consent. This channel has already covered why in earlier videos on vehicle seizure and vehicle searches, resisting doesn't stop a lawful search from happening, and it converts a search you could challenge later into a resisting or hindering charge you're now facing regardless of the original matter's outcome. Error 4. Staying completely silent throughout, on the assumption that saying nothing protects you more than declining does. It doesn't, because silence isn't the same as a clear refusal, and a search that happened while you said nothing at all is much harder to challenge later than one where your non-consent is sitting clearly on the record, ideally on body-worn camera. So here's the phrase, built to do exactly one job, close doorway 1, permanently, without ever needing to argue about which of the other 4 might be open. I do not consent to a search of myself or my property. Say it again, slower, because the second pass is the one that actually stays with you. I do not consent to a search of myself or my property. Notice what this sentence deliberately doesn't do. It doesn't argue that a search is unlawful. It doesn't accuse the officer of anything. It doesn't try to guess which of the 5 doorways might actually be standing open. It simply and permanently removes the easiest one, your own agreement, from the table, every single time, regardless of what happens next. Picture it clean. An officer asks, "Do you mind if we have a look?" You, calm. "I do not consent to a search of myself or my property." If nothing else is said, the officer either has independent grounds under one of the other 4 doorways, or the conversation moves on without a search happening at all. Either way, you haven't handed over the one thing that was entirely yours to keep. The trained officer has a common way of pushing on a declined consent, worth recognizing before it happens on the road rather than in the moment itself. If you've got nothing to hide, why not just let us look? You don't take the bait, and you don't feel obligated to justify a decision the law has already given you outright. Same words, same level. "I understand, officer. I still do not consent to a search of myself or my property." Nothing about repeating a calm refusal gives an officer grounds for anything he didn't already have, and nothing about it makes you look any different on camera than the driver who said yes without thinking twice. Now, the version where a search happens anyway, because refusing consent doesn't make every search stop. If the officer states they're exercising reasonable suspicion under the drugs or weapons powers, or that you're standing inside a designated search area, or that you've genuinely been arrested and this is the safety and evidence search that follows, comply. Don't argue at the roadside. Don't physically interfere. Don't try to relitigate whether the suspicion is genuinely reasonable in the moment it's happening. That argument, if there's one to be made, belongs in front of a lawyer and potentially a court afterward, using the same rondo standard this channel has already covered, not in a physical standoff at the scene, which never once in this country's legal history has produced a better outcome for the person being searched. What you can do, while staying completely compliant, is gather exactly what a later challenge would need. Ask the officer to state clearly what grounds they're relying on if it's a suspicion-based search. That request is entirely reasonable and doesn't interfere with anything. If body-worn camera is available and not already running, ask that it be turned on. Once the search is over, write down what happened as soon as you safely can, the time, what was said, what grounds were given, and the names, ranks, and registered numbers of the officers involved. None of this changes what happens during the search itself. All of it matters if the lawfulness of that search is ever tested afterward. A genuine state-by-state note, because the exact statutes behind these doorways aren't identical everywhere, even though the 5 categories themselves show up nationwide in some form. Victoria runs its drugs and weapons search powers through the Drugs, Poisons, and Controlled Substances Act and the Control of Weapons Act specifically. New South Wales consolidates the equivalent powers into LEPRA, mainly sections 21 and 23, alongside its own designated area provisions. Queensland, South Australia, Western Australia, Tasmania, the Northern Territory, and the ACT each run their own versions with their own section numbers and their own specific thresholds for what counts as a designated area or a genuine reasonable suspicion. The core 5-doorway structure, consent, arrest-related safety searches, suspicion-based searches, designated areas, and warrants holds up as a way of thinking about this everywhere in the country. The specific numbers behind each one do not, so check the ones that apply where you actually live. To close it out, warrants are the search power almost everyone assumes stands between them and the police, and in practice, they're the one you're least likely to actually encounter. The doorway that opens the most often is the one you control completely, your own consent, and the entire value of tonight's video comes down to a single habit. Never give it. Say the sentence calmly every time it's asked for, and let whichever of the other 4 doorways, if any, do the rest of the legal work on its own. This is general information, not legal advice, and specific search powers and their thresholds shift at every state border. Check the ones that apply where you actually live, and speak to a lawyer familiar with your own circumstances if any of the narrower powers, like those tied to firearms prohibition orders or family violence legislation, might apply to you specifically. If a search happens and you believe the grounds behind it weren't genuine, the video ends and a lawyer begins. Legal aid exists in every state. Share this with whoever's ever said yes to a search thinking it made them look less suspicious, or with the mate who's convinced a warrant is the only way this ever happens to anyone. Tell me in the comments, did you know consent was the single most common reason Australian police searches happen at all? More common than every other doorway combined? Subscribe for the next stop, because next time, it isn't your bag or your car they're asking about. It's the phone in your pocket. That video's coming next.